If you or someone you love has been arrested for manufactured delivery of a controlled substance in Texas, I know you're scared right now. Your whole life feels like it's hanging in the balance. I'm Michael Lowe, a board-certified criminal defense attorney in Dallas, Texas. I've been defending people just like you for 27 years. Before that, I was an organized crime prosecutor prosecuting high-level drug cases. I've tried over 150 jury trials. Today, I'm going to share with you the 10 most important things you need to know if you're facing manufactured delivery charges in Texas. This information could make the difference between prison and freedom, so let's get into it. Number 1, understand the actual charge. When you get arrested and you see manufactured delivery on the paperwork at the jail, that's not actually a criminal charge in Texas. That's just the title of the statute in the Health and Safety Code. The actual charge comes later when your case goes to the grand jury. The district attorney will likely charge you with one of 3 things: possession with intent to deliver, delivery of a controlled substance, or manufacturing a controlled substance. All 3 carry the same range of punishment, which depends on the total weight of the substance. And by the way, you can challenge the lab results if you believe they're inaccurate. Number 2, know the range of punishment. This might seem obvious, but you'd be surprised how often even lawyers get this wrong. I once appealed a case where a senior judge, a district attorney, and even a well-respected defense lawyer didn't know the defendant was eligible for probation. The jury was told probation wasn't an option when it actually was. That's why you need a lawyer who really knows these cases inside and out. For example, punishment can get complicated fast when drug-free zones are involved. A drug-free zone finding increases the penalty level. It requires your sentence to be stacked on top of any other sentence. And here's the kicker: if you're convicted in a drug-free zone and sentenced to the penitentiary, the first 5 years must be served as actual calendar time, no parole. Normally, parole can start at just 1/4 of the sentence in drug cases. That's a massive difference. Number 3, do not snitch. Listen to me carefully. I've known a lot of narcotics detectives, both as a prosecutor and as a defense lawyer. These detectives are trained in the art of deception. They will tell you whatever they think you want to hear. They know you're desperate because you just got arrested and you think your life is over. Here's what you need to understand. That detective has no authority to make any deals on behalf of the DA's office. Only the district attorney can decide what happens with your case. For example, the Dallas County DA's office won't even recognize any cooperation unless they explicitly approved it first. Most DA's offices are the same way. Does this mean you should never cooperate? No, but you need a lawyer to advise you first. I've had many cases where my client wanted to cooperate and I ended up getting the case dismissed without any cooperation at all. If you don't need to cooperate, don't cooperate. Number 4, get the search warrant affidavit. Your house got raided and the police left a search warrant. Every search warrant has 2 parts: the warrant itself, and attached to the back is a probable cause affidavit. Both the U.S. and Texas constitutions require that all search warrants be supported by an affidavit stating probable cause. You cannot properly evaluate your case without that affidavit. These affidavits are generally public records. The state can seal them temporarily, but only for about 60 days total. Search warrant affidavits are fertile grounds for defenses. I've successfully challenged them many times. Here's something important. Police officers rely heavily on informants because it's easier than doing the hard work themselves. When they use informants, they have to demonstrate that informant's reliability and credibility. Sometimes they skip steps required to establish that. That's where your lawyer can make or break your case. Number 5, discover the informant's identity. Most of the time, you already know who the informant is. But here's the key. You never want to tell anyone that you know who it is. If the state finds out you know, they won't need to protect the informant's identity. And that leverage can be worth a lot later on at the courthouse. Giving up the informant can be the difference between a first-degree felony and a misdemeanor. I've seen it happen many times. If you don't know who the informant is, your lawyer needs to make them a fact witness. Texas law allows the court to hold a hearing to determine if the informant can give testimony about guilt or innocence of the defendant. A smart lawyer knows how to use this to your advantage. Number 6, schedule an examining trial. In Texas state court, you're entitled to an examining trial before the indictment. That's a probable cause hearing where your lawyer can cross-examine the state's witnesses. Sometimes we can subpoena additional witnesses and get their testimony on the record very early in the investigation. Most DA's offices aren't prepared for these hearings. An experienced defense lawyer can seriously damage their case in about 15 minutes. Once that testimony is on the record, it's hard to change it later on at trial. Number 7, understand search, detention, and arrest issues. This is an extremely complex area of law. I'm not going to go deep into the details here, but your lawyer absolutely needs to be up to date on all relevant case law regarding detentions, searches, and arrests. Constitutional violations during the investigation can get evidence thrown out, and that can make or break your entire case. Number 8, beware of the slow plea. What is a slow plea? Texas is one of the few states that allows the defendant to be sentenced by a jury instead of a judge. This can be a huge advantage, especially in drug cases. A slow plea is a plea of guilty in front of a jury with an election for a jury punishment. A lawyer might recommend that a client do a slow plea if the attorney thinks a not guilty is impossible. The theory is that the jury will appreciate the guilty plea and give the defendant some credit for it in sentencing. Juries can be more sympathetic to addiction issues, it's true, but there's something called the spillover effect. Judges hear the same stories every day. They become hardened to pleas for help. Some judges aren't even paying attention when defendants address the court. The spillover effect works like this. Let's say 6 jurors vote for guilty and 6 jurors vote for not guilty. They might make a deal. The guilty voters agree to give probation if the not guilty voters agree to change their vote to guilty. Even though this is juror misconduct, these deals happen more often than you'd think. But with a slow plea, you've already admitted guilt. The spillover effect is gone. The jury knows you are guilty and can be primed to give a harsh sentence. I've seen more life sentences handed out after slow pleas than any other type of defense. I have never used a slow plea strategy, and I never will. Number 9, find a lawyer who has tried many drug cases. This should be obvious, but most lawyers have never even tried a high-level drug trafficking case. These cases are very different from assaults or other crimes. I've tried more than 50 of these types of cases. That experience allows me to give my clients the best advice about how to handle their specific situation. When your freedom is on the line, experience matters. I can answer your questions over the phone, but don't expect miraculous guarantees in a 5-minute phone call. I'll leave that to the amateurs. Look at my trial record, my experience, my qualifications. You have all the answers you need. If you're facing manufacturer delivery charges in Texas, don't go through this alone. I've been on both sides of the courtroom. I know how prosecutors think. I know how the police build their cases. I know how to defend against them. Call my office, 214-526-1900. The consultation is free. Click the link in the description to learn more about defending manufacturer and delivery charges. If this video helped you, please like, subscribe, and hit that notification bell. I'm Michael Lowe. Thanks for watching.